In Federalist Paper 78, Alexander Hamilton described the relative power of each of the three branches of government. The executive branch had the power of the sword. It enforced laws and wielded the military. The legislative branch held the power of the purse, the authority to tax the public and approve government spending. The judiciary had no power to enforce its decisions. It was, as Hamilton argued, the weakest branch, or as he added, the least dangerous of the three. Then came the Supreme Court case of 1803, Marbury versus Madison. With the court's landmark decision, the least dangerous branch wielded more power than Hamilton and the founders had anticipated. In 1801, America had just weathered a fiercely contested presidential election. Thomas Jefferson, a Democratic Republican, had defeated the incumbent John Adams, a Federalist. In the twilight hours of his presidency, Adams made a flurry of judicial appointments, known as the Midnight Judges. Among them was William Marbury, designated a Justice of the Peace for the District of Columbia. However, the commissions for these appointments, though signed and sealed, were not all delivered before Jefferson took office. Under direct orders from Jefferson, his Secretary of State James Madison refused to deliver the remaining commissions. Marbury turned to the Supreme Court, seeking a writ of mandamus, a judicial order compelling a government official to perform an act required by law. At the helm of the Supreme Court was Chief Justice John Marshall. Like Jefferson and Madison, Marshall was a Virginian. In fact, he was Jefferson's cousin. Unlike the President and Secretary of State, he was a Federalist, the political party of the now former President, John Adams. And up to this point in the Republic's short history, there had not been a major Supreme Court decision. Prior to his appointment to the court in 1801, John Marshall had no experience as a judge. Now, he and the justices faced a crossroads. If they ordered Madison to deliver Marbury's commission, Jefferson would likely refuse, thus undermining the authority of the fledgling Supreme Court. If they refused Marbury's request, it would likely appear as if the court was bowing to executive pressure. Marshall, who wrote the court's decision, chose a third path. In his landmark ruling on February 2, 1803, he first affirmed that Marbury had a legal right to his commission. He then delved into Congress's Judiciary Act of 1789, the very law that granted the Supreme Court the power to issue writs of mandamus in such cases. Marshall declared that while the act appeared to grant the court the power to issue such a writ, that particular provision was in direct conflict with Article 3 of the Constitution, which defined the Supreme Court's original jurisdiction. The Constitution, Marshall asserted, was the supreme law of the land, and any act of Congress that contravened it was null and void. Thus, while denying Marbury his commission, Marshall simultaneously asserted the revolutionary principle of judicial review, the power of the Supreme Court to declare an act of Congress unconstitutional. There were 6 members of the Supreme Court in 1803. The final vote in Marbury, however, was 4-0. 2 of the justices did not participate in the deliberations. Justices Alfred Moore and William Cushing had been ill. All 4 of the justices who decided Marbury were Federalists. George Washington had made 3 of the appointments: William Patterson, Samuel Chase, and Bushrod Washington. Marshall was appointed by John Adams. Marbury did not get his commission, and the executive branch was not forced to act. More importantly, a great precedent had been set. Marbury versus Madison transformed the court into a co-equal branch of government, capable of checking the power of both the legislative and executive branches. 5 decades later, the Supreme Court ruled that Black Americans, free or enslaved, were not citizens and had no right to sue in court. A century later, in 1954, the court declared segregated schools illegal. In 1973, the court expanded privacy to include a woman's right to terminate a pregnancy and denied the unborn the right to life. But in 2022, it overturned that earlier decision. Such scope of power over executive and legislative authority slavery, segregation, and life itself, was established in 1803 when 4 men, Chief Justice Marshall and 3 of his fellow justices, set the precedent of judicial review, the least dangerous branch's greatest power.